she's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground and then had the gall to post another video of it on TikTok. I'm going to be very honest with everybody. I don't plan on fighting. Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you were going to, back on March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and or assault and battery?
No contest.
As does the court. I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by the old, what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Additionally, I believe the interests of justice are well established here in allowing the defendant to plead a no contest so as to not have her guilty plea used against her should a case of civil liability arise, although I question what the civil liability would be since there's no injuries, but I guess that's not for me to determine. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. Anytime it's no contest, especially for civil liability, I'm cautious to overly allocute for obvious reasons. But what I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay. I, in these situations, always advise my clients if they don't do well, there is the risk of jail later, the loss of the delay, the public adult record. She's a relatively young adult. She wants to be able to pursue various careers and ambitions. At the moment, she's working at Qdoba. She's aware she owes some money on some older files, but she is going to, I believe, do a wage assignment, if I understand that correctly. She also has some friends with her in the courtroom who've been supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I ask the court to uphold the guilty verdict. Thank you.
Carnes?
Thank you, Your Honor. This is a disturbing incident involving a defendant and a 14-year-old. Clearly shows some lack of judgment, lack of maturity. However, the defendant does not have any prior convictions. I think ultimately this is a fair resolution of the file. I'd ask the court to place Ms. Jones on a delay of sentence of up to 8 years.
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that online, and I am familiar with Ms. Jones on some other things, but not where she was the defendant. So if the court has
well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Was there charges on that?
She was 18. That was resolved with a civil infraction, I believe. I'm just going purely off memory, Your Honor.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what this type of thing is designed for. A delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that. But I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor here and as judge, and I believe she has another case coming up that she has to be arraigned on with Judge Van Olts, because I had a conflict on that because I was the elected prosecutor when that was arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court or somehow tied with other events. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept on. How is your daughter doing?
She's doing good. I mean, it affected her, but.
How so did it affect her?
Well, just being out, walking around town, she didn't deserve that. She'll get through it.
Okay. Anything else you'd like me to know?
No.
Okay. Thank you for coming today. You can go back out.
One thought that came to mind throughout this case was the saying that hurt people. I do recall a case where Ms. Jones was a victim of felonious assault, and then it's unfortunate to see her as the perpetrator in this case. My hope with this plea offer, would be that she could be rehabilitated to break that cycle.
Ms. Jones, you had the right to address the court before sentencing. Is there anything you'd like me to know?
I'm very sorry. I never intended to hurt her. I was trying to look like that. And I even myself was very shocked seeing the video. And I'd love to get into.
You'd love to what? I'm sorry?
Get into management classes and more help.
Well, I know you've been through a lot, and I'm familiar in the various roles I've had of the different issues that you've had. And now that you're back on your medications, have things kind of leveled out for you?
It's coming.
And are things going good at your job? The mitigation report describes your peers as saying that they consistently describe you as caring, reliable, and helpful. That certainly wasn't you this particular day, at least as I read in the report. And I don't want you to make a comment on that. But do you understand my concern with putting you on a period of probation that's going to basically allow you to erase your record? Do you understand that concern I have?
Yeah, I understand.
And again, without any comment, because of the no contest plea, at least the way the report describes, you went after this girl pretty hard. And it sounds like she had some effect from that based on what her father said. And as I said before, the law is designed to recognize that young people in certain situations do stupid things. Not that I find that this was excusable by any means, or that this was a stupid thing. This was you physically attacking a 14-year-old girl over a comment that was made about somebody else's mother, deceased mother. And then if I recall correctly, there's quote unquote round two video for TikTok. Yourself were a victim of a felonious assault, and if I remember correctly, Mr. Carnes, was that the gun being pulled on her?
Yes, Your Honor.
And then you turn around and assault a person who's 5 years younger than you. And you're an adult. She's 14 years old. But at the same time, I realize that you have a struggle aside from this that you need to overcome. And I don't necessarily want to saddle you with anything further. I am a firm believer in allowing people to shape their own destiny, so to speak. So I am going to follow the recommendation. I'm going to put you on a delay of sentence for 12 months. That's the longest period I have available to me. If you're not successful, the conviction.
I think I can't do it in the jail. I know I'm 19, but I'm behind, a couple years behind, and I would like to catch up and live peacefully and happily and get a better chance at life. I don't want to end up this year.
I do find that she is still a threat. She went to somebody's house, at least allegedly, to get her earphones and wound up.
Personally, I think the most frustrating part of this case is that Miss Jones was given exactly what so many defendants ask for, a second chance. The judge had serious concerns from the beginning, but still chose rehabilitation over immediately leaving her with a permanent conviction. Then, just 1 month later, she was back in court facing another alleged assault. At some point, second chances have to come with accountability. Her age and personal struggles may help explain some of her behavior, but they don't erase the impact on the victims. Let me know what you think. Did the judge show too much mercy, or was probation still the right decision? Don't forget to like and subscribe.